Good afternoon, everyone. Welcome to AmeriCollect's webinar, The Verdict is In. My name is Luke Check, and I'm part of the Ridiculously Nice sales team. I'm happy to be your administrator for today's session. If you have a question during the webinar, please email sales@americollect.com. Now on to our presenter. Kenlon is the president and CEO of AmeriCollect, and he's worked in the collection industry since 1988. He's the owner of AmeriCollect since 1999. Kenlon, take it away.
Thanks, Luke. I appreciate it. I hope you've got your Halloween costume all picked out. Luke, do you?
You do.
You do. Good for you. Good for you. You're going as an Easter bunny again, aren't you?
No comment.
No comment. All right. Anyway, hey, thank you for joining us in this webinar. We got a surprise we're going to tell you about in a little bit, but why we're here, we're trying to change the way that collection agencies are viewed by being nice to consumers. Consumers respond to nice people. They pay your bills, they pay us. They're more apt to take our calls and work things out. And so we appreciate you joining that cause. That's why we're here, is to change how agencies are viewed. And so thank you for joining us in that. You know, ridiculously nice collection agency. That's what we're trying to get away. And that's who I am. This is our surprise. Attorney Kerry Bilka is with us here today. Kerry, you want to say hello to the guest audience?
Oh, good afternoon, everyone.
Kerry and I were just chatting. So Kerry's his practice is here in Manitowoc, Wisconsin. 1977 graduate of the University of Wisconsin-Madison, a very prestigious law school. Originally from Mitchell, South Dakota, or around there, you said. Huh?
Yes, a small town.
Kerry and I were talking about how we met. He's been our attorney here for years. I still looked up the specific date, but he in 1994 he went on his own and in Manitowoc, and we're trying to remember how we met each other. And I believe that it was at another attorney's house, and we had a poker party, and everybody bought like their own six-pack of beer. And I just remember the coolers. You guys are a little bit older than me, so I was a little intimidated by being with like four attorneys. It was Wedemeyer, you, Lambert, I forget who else, but anyway. So Kerry's going to be here to help us guide through this process. We're going to speak in general terms because there's people from all different states on this webinar. But, you know, being prepared for a trial is pretty much the same in every state. Yeah, so he may call it something, and you might say, well, what's that? Well, it's probably in your state, but maybe they just call it something different. So we're going to start, and we're also going to use healthcare mainly as a talking point. At AmeriCollect, we're at about 3/4% of the judgments that we take end up being set for some sort of trial, but most of them get resolved beforehand. In fact, ironically, I just got this email today. I don't think you've seen this. This is a state that uses mediation, and so they have a company that they hire. So when it's set for trial, there's mediation, and you know we're trying to change the way that collection agencies are viewed. And one of my coworkers here had this neat email, and it just came in today. It says, I've done this for 12 years, and I've done over 5,000 of these. And I'll say that was the best response email I've ever got from an attorney staff collection agency because you explained it perfectly, which is how I try to explain things to people, and what makes sense for the creditor plaintiff as a payment compared to what you'd get otherwise. Anyway, it's a nice email. I just got it in this morning, and I thought this really exemplifies what we're trying to do here at AmeriCollect, to work with consumers to pay, even if they set it for a trial, because the last thing that we want is for you, our clients, to have to leave your office and then go to a court case, show up, and then half the time they don't show up for the trial. So our goal is to get these things worked out beforehand. But what happens, though, if it has to be set for a trial? And that's what we're going to talk about today. So, Kerry, I'm going to change to this slide here before the hearing. So what happens? Someone goes to small claims. They show up in court, and they say, I want a hearing. So we now notify the client about that. Then what should they be doing to be prepared in advance for this? They might have 30 days, 20 days to prepare for the trial, sometimes 60. Is that about right?
Well, it varies from county to county depending on their caseload, but some counties don't set a case for a hearing right away. Some schedule it for mediation. Waukesha County, for example, has a mediation program, and you're required to go through that process. Although in Waukesha they do set a hearing date, though, right, further out, probably about 45 days after the mediation is supposed to be set up.
So either way, though, is once they find out, they should start getting their ducks in order, like the itemized charges is what you're saying. So itemized charges that would include these kinds of elements, the date of service or the date of charge?
Usually, yeah, that is something that we'll want right away. I do, as soon as I find out about the hearing, I then notify the client representative and the account handler here at AmeriCollect, the primary people in charge of the cases, the claims that go to a court filing.
Well, one of the things that the itemized charges, typically when we start a small claims, we don't include the itemized charge because we don't need all of that data out in the courts as becoming court record. So we wait until there's a hearing, and then we send that request saying that they need a particular itemized charges. And for most clients, they can just kind of print it off the system, and they can print off their itemized charges. But one of the things that you're also talking about on the next slide is that you're going to need additional documentation, like billing documentation. Do you need a copy of all of the statements that were sent out? Because in today's world, as you know, it really isn't we don't keep a copy of that statement. Or do you just need to know what was included and what the frequency of those billing documents? Is that what you're talking about?
It may depend upon whether the debtor is contending that they never got a billing statement. I hear that quite often on these disputed cases. This is the first time I've ever heard of this, especially with, well, in the healthcare fields, you sometimes have ancillary services.
Oh, radiology, ER docs, things like that.
And sometimes they aren't able to get perhaps the most current address. So they depend sometime on the primary healthcare provider, the hospital, or the doctor who referred the patient.
So for this, is it as simple as them stating in an affidavit that this is the address that we mailed it to, and these were mailed on this, and this days? Is that good enough, or do they need an actual copy of the billing document? That's hard to get to sometimes.
Yeah, if that becomes the issue, we do ask the creditor's account representative if they can easily access that and provide it to me, because if we can then send that to the debtor and say, look, this is what was sent to you, this is what the address used was on that document, we can basically lay it right in front of their face and hopefully get them to concede that they got it.
So getting that information in advance right away is helpful in case that becomes a defense, even if they didn't bring it up and the answer, the consumer could bring it up at the time of the hearing or the trial, correct?
Well, it usually is known early on if that's the reason they're disputing it, and then they often have other reasons. But I do try to, as part of notifying the client representative about any hearing that is scheduled at which we may need to have them give testimony, I do try to, at that same time, ask if they have some additional documentation that might help. As far as the primary documentation, be it the account ledger, if it's a utility account, or the account record, if it's a healthcare provider, goes by date of service, the procedure code, the original amount charged.
Well, explanation of benefits help sort of tell the whole puzzle of the story, and also for healthcare accounts. So it's important for you to get a copy of those.
Not so much necessarily. I only try to get those in circumstances where the debtor is saying, well, you didn't send a claim for this to my health care plan, or you didn't submit the claim properly to my health care plan, and that's why they denied it. If you can, as I'm sure all the listeners know that are with healthcare providers, hospitals, or physician offices or such, I'm sure they've seen many of these over the years that they've done this, but of course these EOBs will have an explanation on them as to why the health care benefit plan didn't pay. The insurance, as the debtor always calls it, my insurance didn't pay right. So that often helps me then send copies of that to the debtor and say it wasn't for the reason you think it was because you didn't do something. Oftentimes the explanation of benefits will show that the claim was denied because the, I'll call it insurance plan or the health plan, sent something out to the debtor requesting more information about the circumstances of why the services were needed, because they want to seek reimbursement from some third party if it's
Sure.
a car accident or if it's work comp.
Do judges generally get that understand? We call that coordination of benefits in the healthcare world. Do judges really understand that concept and say, listen, that's not the provider's, healthcare provider's fault? And do they get that usually?
For the most part, but if the debtor's asserting that the claim was not made properly by the provider, they will listen to that.
Well, but what about a lot of the admissions agreements that healthcare providers clearly state that we're offering this as a service to bill your insurance company, but in no way are we obligated, or, you know, most admissions agreements that I see have that wording on that. And even though we have that agreement, you have whatever judge does whatever they kind of want to do. Is that a point? Your next point is a signed agreement to pay. Does that ever come up where, you know, so you want that signed agreement to pay, which is great, but what happens if they throw that at you? Well, you didn't file the health insurance correctly.
Well,
whose ownership is this to pay this bill or get the bill paid?
If the healthcare provider has taken it upon itself to submit that claim on the patient's behalf, so there is some responsibility to do it correctly and get them the proper information, and there could be an issue as to whether it was done correctly or not. As far as the signed agreement to pay, I've had that become especially important, and there are cases we've had, claims we've made, where the debtor says, I wasn't the one who got those services. They claim somebody used their name to get the services at the hospital. So in situations like that, if there's a signed agreement, that can be very...
Perfect, yeah. Well, what about things like utilities, though? Oftentimes you sign up online. What do they call that when you receive the benefit, you know, and even though you might not have signed for it, you know what I mean, or there's no written agreement, or you called up and you used service and you called up to turn on a particular service. Any issue there? I mean...
No, I mean, it's basically similar to charges for health care, too. You know, the physician's offices, they don't have signed agreements typically either.
Not always.
It's a quasi-contract based on what a Latin term called quantum merit, the value of the services. The person who provides the service is entitled to be compensated for them.
Well, you think about like radiology practices and things like that. Oftentimes there's no agreement at all, but it's in the sort of the hospital's agreement that they're allowed to send for services, and you know, and so that's usually covered. And but, you know, you also have in your staff notes. What I would be concerned with if I were a creditor or provider is that all of a sudden these notes become part of the public record. So do you use this information just to sort of get a bigger picture of exactly what went down, so to see where this might go? Or does all of this become part of the public record? Or can a client sort of say, listen, I'm going to give this to you, but I really don't want this to be used? Your thoughts about that?
Well, certainly in the healthcare field, we have to be cautious about laying out protected healthcare information in a court file that is, in this type of case, open to public inspection. Not that there are people out there that just wander in and say, I want to look at a bunch of files, but,
you never know.
But still, it's available to the public. What I'm talking about here, though, is to address a debtor's contention that they were, for example, no one ever called me, no one ever contacted me. The account notes are typically very detailed, that the patient account departments maintain, or the utilities maintain. They log in notes as to just about every contact, including those with the responsible parties. And those can be very helpful in showing people that very, good, diligent efforts were made to contact them about their accounts. You'd be surprised some of the information you see in there that contradicts what the debtors are asserting in an effort to defend against the claim, to dispute the claim.
Well, and we all know that a lot of times consumers raise defenses, and oftentimes it's just simply I can't afford to pay you in full today, I need some more time. and now they set up for a trial, and now they're, what do I do? And a good percentage of the time you show up for trial with the client, and the defendant doesn't even show up. So, but when they do, you know, they're going to question some of these things.
As far as the staff notes and patient account records and concerns about confidentiality and making sure that they're not open to the public, that I was going to get to that a little later, but once it comes to a hearing and when these documents are used at a hearing, arrangements can be made with the court typically to either have them placed in a confidential folder in the court file or withdrawn.
Oh, really? Okay. Well, let's talk about it when we get to that slide. The next one, you talk about a summary of the unpaid charges. So in the previous slide, you talked about more of an itemized statement. This one, you're asking for some sort of chronological order. Are you looking for something relatively simple that, because I mean, I've seen print-offs from some of my healthcare providers, even utilities. Unless you're used to seeing it, it's hard to interpret. It's very Greek. So are you looking for something so simple that you can lay it out before the judge and before the, almost like in an Excel spreadsheet saying, here was the charges, here was the insurance adjustment, here was the insurance payment, here were the personal payments, by account, by data service? Is that what you're looking for? Just a simple document that sort of ties back maybe to the statement of charges? Is that what you're looking for?
You pretty much said it exactly. It is always very helpful. When I request and receive copies of the account documents, sometimes on some of the claims include charges over a long period of service, and you don't get there's a lot of information under each charge as to what happened, credits for health plan payments and discounts and adjustments. All that can run into 50 pages. Well, there's nothing that a judge or a court commissioner hates worse than having to deal at a hearing with, a document that's 50 pages long in a small claims case, which they just want to, conclude as quickly as possible.
So would you bring those 50 pages along, or would you just bring this along and say, I have it here if you want to see it as an additional exhibit?
Well, we would want both there.
You would.
To have the backup information for reference if necessary to get the detail, but that it is often helpful, and many of the healthcare provider clients will be able to generate that. I've been getting some, and it's very nice to have those, and I know that courts appreciated that. You see the data service, original charge, payment from health plan adjustments, and then the balance in the far right end of that line on columns, basically, and it's a spreadsheet type of thing that
I think we have a form here that we send to some clients that don't use it, so that we might maybe do a better job of getting that to all of our clients, saying, hey, this is separate, so could you fill this out so that it makes sense? And that, when you have repeat court commissioners and judges, that they're used to seeing it then, and I'm sure that if they can understand it, I think they can sort of steer those cases in the right direction. The next slide we're talking about is summary judgment. So what does summary judgment mean? Just you request the court commissioner to say, hey, I get to win, or what does that mean?
Well, it's basically a motion procedure provided by law that the person asserting a claim, or defending a claim for that matter, but we're in the asserting a claim business here, can sometimes use to bring the claim before the court supported by appropriate documentation of the services that are included in the claim as on a sworn certification by someone who can do this as a custodian of the records.
So this is even before it goes to trial. Yes, so if you can get a summary judgment beforehand, you can quash their what they're claiming by saying, here's some paper proof and here's an affidavit, and sometimes they'll kick that case out. That's what you're saying.
Well, it's essentially that. It doesn't work real well very often in a small claims case, which in Wisconsin is a case involving a claim up to $10,000. Mm-hmm. the procedures for moving that forward to a hearing move along a lot quicker than with a case in which a claim asserted is over $10,000.
So civil action versus small claim.
So it's most often used in the
the
big court case, as we call them, to try and bring it to a conclusion without having to have a formal hearing before the trial judge assigned to it.
And so all of the information that we've talked about before would be included in the summary judgment, or the majority of it, what you need to prove it. And so so it's a tool that you use to avoid the creditor to have to show up in court. Okay, but not used all the time. Okay, I think, and that's what you're basically talking about, these bullet points here. Is that
there would be a document prepared, and the client representative would be signing it, saying they have authority as a record custodian to certify that basically the attached account record is a true, genuine, and correct copy of the original records on file and maintained in most cases in the computer record-keeping system.
I get this question every once in a while, that the representative is a custodian of the, I think some of our people that work for our clients in the healthcare and the utility, they're afraid to sign that because they didn't touch every little, they didn't take the, they weren't there when the person signed the admissions agreement. They didn't take that first phone call. They didn't file the insurance. And so can you put some of our clients at ease that it's okay for them to sign this because they understand that your health system employs 3,000 people, and we can't get the signatures of everybody that touched that patient. So explain the relationship of the custodian thing and how that works and why they need not be so fearful of it.
Well, if I submit a proposed certification of an account record to someone, I'm basically just asking them to certify that they have authority to access all those patient account records, to view what is in their employer's record system as to the patient accounts, that they have some authority to perhaps generate copies of that into hard copies of that information that's maintained in their digital files, and that they know that the hard copy produced is truly a genuine reproduction of the information that is recorded in those digital files. It's basically a certification that it's genuine copy of the account records of their employer.
The next one, we're talking about summary judgment. We've kind of talked a little bit about this, is that what we're talking about, the record made at time events during regular activity, regular course. That's all those custodial things that you were talking about.
Yeah, that's something that kind of language is what I would have in the proposed certification, the written certification that I would submit to the client representative to sign on its behalf. And I'll get to this maybe a little bit later, but it's primarily geared to bring these records before the court, show that they're genuine, and show that they meet the qualification of a business record that is allowed to be received as evidence by the court as an exception to what's called the hearsay rule.
So you might, okay, all right, so I think I get what you're saying there. Because once in a while, some of our clients will say, well, why did the attorney ask this question, especially if they're in front of someone at a hearing or something like that, say, why did they ask all of these kind of questions that are kind of meaningless, but you're trying to go on the record so that someone later on can't say that this was hearsay? Is that what that's about?
Yeah, you're trying to avoid, it's not likely going to be an objection from the debtor unless they've heard of the hearsay rule, but sometimes the presiding official, the court commissioner, or the judge, depending on the county, is well knows the hearsay rule, and you've got to sometimes cross all the T's of the statutory criteria you need to meet to get the record admitted as an exception to the hearsay rule as a business record, and we'll cover that a little bit more. But also, with the proper authentication that it is, you know, a truly genuine copy of the record, and how it gets created. There's also a statutory presumption then, which is very critical in healthcare provider claims in Wisconsin, because it is the healthcare provider's obligation to establish that the services they provided were reasonably necessary for the patient, and that their proposed charge is reasonable in amount. And there are more difficult ways to do it, but the easy way is to meet this certification requirement, because then the statute that applies states that there is then a presumption that the services were necessary and the charge was reasonable in amount. And then the burden shifts to the responsible parties to try and submit some proof to the contrary, yes. And that's almost impossible for them to do, well, because it basically requires expert testimony of someone that is involved in the medical field, for example, in the establishment of amounts to charge for various services and so forth. You'd have to have that kind of expertise, testimony from that kind of expert to dispute and overcome that presumption of necessity and reasonableness.
Well, and I think that that's one of the things that our clients sometimes, you know, I work in the business office of a healthcare provider. How do I know what's reasonable to be charging, you know? And of course, insurance companies deny bills, saying that they're not usual, customary, and reasonable charges. And so that term flies around in the healthcare world from insurance companies saying, we're not paying you that amount, we're paying you this amount because you're overcharging, quote unquote. And so, but I get what you're saying. So you're saying that there's a statute that says that it's the providers, at least in this state, but probably in other states too, that it's their responsibility to prove up that the charges were necessary and reasonable. So the services were necessary, and that they weren't just running on charges to run on charges, and that they're reasonable in cost. And a simple statement to that effect would be good.
Well, it's not just a statement. You'd have to do it in a formal, sworn document. Basically, it's an affidavit. I call it a certification of account record. Again, it's a little cumbersome to do in the context of a small claims case, but it's then done at the hearing by the client representative who is intending to give testimony in support of the claim. By their sworn testimony, certifying that this document we have in court, marked as an exhibit, is a true, genuine copy of the record, etc.
Let's talk about, move on to this slide here, which I think is one of the communications with attorneys. So, of course, there's in Wisconsin, there's 70 jurisdictions, and we filed the cases through your office, but you can't be in 70 different jurisdictions at once. So we use appearance attorneys. You want to talk a little bit about that relationship, and just touch a base on that, and that you might file the initial summons and complaint, but
yes, and generally any county that isn't contiguous with Manitowoc County, where I am, I'll do the ones that surround us here. But beyond that, it's much more efficient and economical to make arrangements with an attorney in the locality of the county in which the court claim is filed to actually attend the hearing if we can't get it resolved ahead of time. And I suppose we kind of glossed over that. I just might mention I make every effort possible to try and reach a payment agreement with the debtor in writing that will eliminate the necessity for a hearing. I don't like having to trouble the client representatives to attend court hearings, especially in counties that insist on the witnesses being there in person. It's I am very aware that it's a big hassle to have to leave your office, go to some courthouse you're not familiar with in Milwaukee, find a place to park, or in Madison.
So you're saying we should sue more in Hawaii then, huh? Then it would be worthwhile.
Then the client representatives might
the amount of money owed better be pretty big. So.
But their supervisors might not appreciate
right.
it.
And so that's something that's sort of out of our control. But I mean, what you're talking about is the stipulated agreements and things like that. And
yeah.
Do you want to, in a short, explain what a stipulated agreement is in just a nutshell?
Yeah, basically it's a written agreement. I call them a conditional dismissal agreement because it contains provisions that set up the payment obligation of the debtor, the total amount they have to pay, and then the payments they have to make either on a pay period basis or a monthly basis. Typically, we just set it up so much per month.
Yep.
It provides information on where they make their payments. And the ultimate provision in the agreement is that the case gets dismissed, closed out, but the creditor, the client here, has a right to file a motion with the court to reopen that case to enter a judgment for the unpaid portion if the debtor goes into default in meeting the payment terms. If they don't make the payments that they agreed to make in this signed agreement, then we can file a motion to basically vacate that agreement, reopen the case, and have a judgment entered for the amount they haven't paid.
Now, if they miss the payments and you make the motion for that they missed the payments, does it reset for a trial then, or does it just boom, it's entered?
The only issue at that point is, did they make the payments or not on time?
And typically these disputes are almost always, at our office here, we try to steer clear of the ones that are highly disputed when there's a known issue. We try to work those out on our own, you know what I mean? So oftentimes we walk into these cases that are set for a trial, and the consumer never told us that they had an issue. We kind of go into it blindly. It's like, oh, we found out that they're working, they have a good job, they own their house, they're making good money, and they just haven't been returning our phone calls. Well, the reason they haven't been returning our phone calls is because they're afraid to communicate with us, which is what we try. But so this stipulated judgment is a really good tool. We looked at the statistics on this not long ago with our organization, and we were surprised at the amount of times that we use that tool. It's a good number of cases. It's like 15-20% of them that we're using it in, and so it is a good tool to be using. So
I send out the letter with the proposed agreement in just about every case. Of course, I do it with consultation with your staff here as to what they think we should propose for a payment amount, so much a month, that kind of thing. In my letter, I try to explain to them the advantages of resolving this claim with that type of agreement.
Well, it doesn't go in their credit files of public record, so that's a good thing. I mean, eventually it gets dismissed, so they won't have a judgment record against them, which is good. Let's move on. We've got a limited amount of time here. So appearing as a witness, okay, I'm nervous. So what's the hearing versus a trial thing? Explain that to me.
Okay, but first, as far as nervousness, I can imagine the first time you do this, it's a little unsettling, but it really isn't something you have to fret over a great deal. It's just a matter of a little preparation and taking a deep breath and listening carefully, as we'll cover here. And if at any time, once you find out that a hearing has been scheduled in a matter and you're being asked to testify at it, at any point along the way you have some question or concern, don't hesitate to contact me. As the court date approaches, most of our appearance attorneys in the other counties are going to want to have a little communication, a little preparation, telephone conference with you 2 or 3 or so days in advance of the court hearing just to review the records together so you're on the same plane. And as far as and the contact information, when we do have a county where there isn't going to be an appearance attorney, at some point before that hearing date, I'm going to send out, usually by email, information as to who the attorney is that will actually be there in court handling it with you, their contact information. And once that attorney's contacted you directly, you can field any questions you had with that attorney also. We work closely together.
Yeah. So what's the difference between a hearing and a trial then?
Well, there we're talking about what in Wisconsin we have quite a few counties where the claim is first dealt with at a hearing before a court commissioner.
Okay.
Now, these are attorneys who are appointed to act in some capacities in the court system. They can do certain things, and one of those things the law authorizes a court commissioner to do in certain counties, if the counties choose to use them, is to hear claims that are small claims cases, under $10,000. Those hearings before court commissioners are typically conducted a little more informally than they would be conducted if they were before a judge. Oftentimes at the court commissioner hearings, in fact, I don't know of any court commissioner hearings in any counties where they're done, as they call it, on the record, with a court reporter there taking down the testimony.
So it's an effective way for counties to save money also, I suppose.
It is essentially a screening process. People get their first go-around at dealing with the claim. The debtors who are disputing the claim get their first chance to support their dispute of the claim before a court commissioner. Oftentimes, in the court commissioner hearings, they can be as informal as here in Manitowoc County, where basically the court commissioner just asks the plaintiff to describe what their claim is. Often I can go to these without even a client representative there. And as the defendant then turns to the defendant and has them tell us why they're disputing the claim and what information they have with them that supports their dispute. Some court commissioners in some counties, though, get as formal as having witnesses go up and take a chair, a witness chair, so to speak.
Let me move on here. So some general guidelines, okay? So that you're talking answer in words. What else would you answer?
Well,
nod in your head? Okay.
Nod the head, shake the head. That is not answering the question. And especially if this hearing is actually a court trial in front of a judge, and not just a court commissioner, and you have a court reporter there taking down the testimony on their court reporter machine. They can't take down sounds. It has to be words.
When you say yes, no, are you saying that just only answer in yeses, no's, don't add any more to it? Is that what your advice is here?
Essentially, that's what I'm saying. If that is sufficient to answer the question, that's all we need. A simple yes or no, maybe a couple clarifying words after that. Yes, that is what I heard. Yeah, no, that did not occur. Basically, it's a simple statement answering the question, if that will answer the question.
If I needed to request clarification, is there a formal way to say that, or could you rephrase the question? I mean, you know what I'm saying? It's like we've all seen the TV shows, but what is there a formal way to do it, or just say I'm not sure I understand the question?
Either just as you put it, or if it's perhaps a particular word or phrase that's used in the question, you can say to the attorney asking it, if it's me, I'm sorry, but I don't understand what you mean by the word, whatever it may be, that you haven't heard before or don't quite understand, or by the phrase.
What if you have a consumer representing themselves, and they're asking questions that have nothing to do with the amount of money owed for this particular data service, but they're bringing up the cost of healthcare in general, or you know what I'm saying? They're way off base. I mean, whose job is that to say, well, that's your job?
Well, that's where our attorney, the client's attorney, me or the appearance county attorney, would step in and raise an objection to it. And what you're getting into there is when our witness is being, in effect, cross-examined by the defendant. All we have to do is put in our, what they call a case in chief, the basic supporting evidence to support the claim. Then the official presiding judge or commissioner will allow the defendant, or in a rare case in small claims court, the defendant's attorney, to question our witness.
Okay. All right. Well, good advice. What about the testimony? So you talk about access to account records. So they should have them with them?
Okay, here's where we're getting into, and this applies to both healthcare providers, utility companies. We're getting the account documents admitted as business records so that they can be received under a rule that permits hearsay information to be received. And by hearsay, I mean basically documents that were created by someone other than the witness, records and documents, and created before the hearing at another location. They're extraneous information that this witness did not personally create in most situations. They're coming in as basically the record custodian to swear to these records, and these are the basic elements that have to be shown to get business records admitted as an exception to the hearsay rule. Basically that the information provided in the record describes events that occurred in the course of their business, that these entries in the records were made at or near a time that these events occurred. In other words, contemporaneously with what occurred, somebody's making a record of it. That's their course of business. That each entry in the record was made by a person within their employment or acting as their agent that would have had the knowledge of that information, the personal knowledge of that.
Let's move on to a couple more. So you're talking about the exhibits displayed, kind of all of these things, and the event, the time of the occurrence, the person of knowledge, all of those things are going to be established during the testimony, typically by questions that you would ask, correct?
Yes. You know, as the client's attorney here, we're going to do our best to try and kind of lead them through the questions and kind of phrase the question in a manner that sort of suggests the answer to make it easy for them as much as we can. We can't lead too much because when you're presenting a witness under direct examination, as they call it, in support of their claim, that's supposed to be leading the witness and basically just totally feeding them the answer. But we try to phrase the question so that pretty much the gist of the answer is there for them to affirm.
And you can kind of do that in the tone, too, that you're delivering it with the voice. So what you're telling us is that kind of a statement?
Well, something to that effect.
Okay, but not quite
tell us whether or not these entries in these records were made by a person who had the knowledge of the information that is recorded in them, in each entry.
Yes, they did. All right, you led me pretty well there. All right. We're talking more about exhibits. I kind of want to, because we only have about 3 minutes left here, I kind of want to get down to the cross-examination part. That's the part that we were talking a little bit about, but...
sometimes, especially when the defendant, the debtor, has an attorney, there's going to be some cross-examination by that attorney on if there is a valid issue before the court on this thing. And so it's very important to just remain calm, listen carefully to the question that's being presented to you by the debtor or the debtor's attorney. Pause for a bit to think about that question and how you're going to phrase your answer. As we have at an earlier point in this outline for the presentation, don't start answering the question you're being asked until you heard the entire question. Because, number one, you don't truly know what the question is till you heard the whole thing, even though you think that you know what the question is before it's totally stated. It's so tempting to jump in there, jump on the question with an answer before the person is done asking it. But try it. You got to try to resist that because it gives you a chance to think about it too before you pause a few seconds to think about how you're going to phrase your answer. Always be truthful, of course. Speak up when you're answering to make sure that the official can hear you, the judge or commissioner. Don't argue with the defendant. Don't insult the party asking the question. Be polite. At all times, just state the facts as they are. And here especially, if a yes or a no will do, that's fine. But sometimes it takes a no. What you stated is not correct. A few more extra
Are there any types of questions that don't have to be answered?
It's possible, but usually that comes when the attorney objects.
So you would object saying so
to some irrelevant question, and then the judge says sustained, meaning the objection is sustained. You don't have to answer.
All right, all right. So I mean, oftentimes you see that the creditor's person on the stand will look to you. How should I answer that question? And describe that. I mean, that has to be an uncomfortable feeling for you, because you really can't help them answer the question.
Well, sometimes you interject an objection to possibly give a little more time for the witness to think about the question, or to, in effect, try to get some clarification from the person asking the question if it appears to be muddled, or causing some puzzlement on our witness. It's a matter of case by case and question by question, but it can happen, and I try to interject to get it clarified.
Interesting. And the last thing you talk about is custody of the documents here. And so you can actually request that the documents be labeled as confidential. Is that what you're saying?
There are sometimes when there's a couple counties where I can do a hearing by telephone by getting our witness on the phone in a conference call that I then make to the court. I have to get those exhibits to the court ahead of time, though, and when I submit them, especially in the healthcare claim arena, I submit them with a letter requesting that they immediately be put in a confidential folder in the file and not be available to the public because it's confidential healthcare.
Otherwise you ask for it back.
Yes.
Okay. All right. So the defendant doesn't have a right to those documents at all?
Well, the defendant can have a copy.
Sure. Oh, okay.
It's their records.
Sure. Right.
Typically, you got to be a little careful if it's a spouse situation where there's been a divorce.
Yeah. Right.
But you're still making the claim against both spouses. I have to sometimes be a little careful about what is disclosed to the non-patient spouse.
Yeah.
As far as information about what the services were, even though that non-patient spouse, if they were married at the time, is jointly liable.
Yeah, I hear you. We get those every once in a while. Well, hey, we're all out of time. Carrie, you do a good job for us and for our creditor clients. We appreciate that. And you do a good job, I think, resolving them before there has to be a hearing or a trial. And that means a lot to our clients, and we really appreciate that. So, and I appreciate all the work that you did putting this in here. And again, if you have any questions, you can email them to sales@americollect.com. We didn't want to make this too specific, but we'd also invite you to our next webinar. You hired them, now you need to fire them. So making the transition easy for all involved when you decide to part ways with your collection agency. Now, if you're a client of ours, we don't want you to watch this webinar because you're not going to fire us, are you? I hope not. Anyway, we're going to talk about how you can make that transition easy, letting go your agency, and still having a good relationship with them. That's on Tuesday, December 3rd, from 1 p.m. to 1:45. We look forward to it. Hey, and one last bit of news. Since the last time that we had a webinar, for the 5th consecutive year in a row, AmeriCollect has been named the best places to work in collections, 5-time winner. We don't know where we landed yet. We've landed as high as number 3 in the nation and as low as number 7 since 2009. So congratulations to the hardworking staff here at AmeriCollect who understands what it means to come to work and be happy in what you do. And thanks for choosing AmeriCollect and that continued effort in changing how collection agencies are viewed. We appreciate you all. Have a great day, and don't forget to dress up for Halloween. Thanks.